the argument schedule. Okay, our third case today is, hang on 1 second. Elite Holms et al. Versus Odievich.
Good morning, Your Honors. May it please the Court. Brian Wade on behalf of Elite Holms Northwest, LLC, Vadim and Valentina Sherbinin, who are present in the court, and their son Nick Sherbinin, who is the owner of Elite Holms, LLC. I'd like to reserve 2 minutes for rebuttal. And at the outset, I'd like to make 2 specific points, hopefully succinctly. On May 27th, the Washington Supreme Court heard oral arguments in an appeal from this court's decision in Horvath versus DBIA Services. Horvath, albeit, was the issue is the standard of review when applying the multi-factor test under the Public Records Act. Nevertheless, this court had held that abuse of discretion applied to that, even though the trial court had decided it on summary judgment. The Supreme Court explicitly granted review on the standard of review issue. On the petition, all of the briefing on both sides acknowledged that de novo review, rather than abuse of discretion, was the proper standard. In this case, I don't think it makes a lot of difference whether the court applies abuse of discretion or de novo standard, because the trial court's error was so clear as a matter of law.
And you're talking specifically about the application of judicial estoppel.
I am, Your Honor. I am.
And that was and judicial estoppel was the issue in Horvath as well?
It was not.
Okay.
But this court's decision in Horvath is whenever the trial court's exercising discretion, such as deciding an equitable issue, the standard of review is abuse of discretion. That appears to be on the verge of being reversed in the Supreme Court. Not a single justice asked a single question about the standard of review issue, and both sides had agreed that de novo review was appropriate.
So you argue very clearly that the standard of review as the application of judicial estoppel is de novo, and you rely on a footnote from a 2014 opinion out of this court, Taylor versus Bell. It's a footnote that poses a question and expressly declines to answer it, but that reliance on Taylor on this particular question ignores prior and subsequent case law out of this court that definitively says that when we're just looking at the application of judicial estoppel, where it arises in the context of summary judgment, you apply abuse of discretion as to the use of judicial estoppel, and then you get into the de novo review after that. So why would we follow a question posed but not answered in a footnote as opposed to this other body of case law?
I also addressed the Chona case out of this court, in which the court said, we look at it the same way as the trial court. Now, that's de novo review. But again,
I'm asking about the broader body of case law that says very clearly that we apply abuse of discretion standard to this particular question before we get into that other analysis. And toward that end, you do in briefing set out the factors that we consider when we're looking at judicial estoppel. But where in briefing did you apply those factors to the facts of this case? I see one conclusory sentence that they don't meet them, but I don't see in your briefing where their analysis applies those factors.
Well, none of the, as we pointed out, none of the factors are met here. None. Now let me get to my second point, which I think is responsive to your question. In relative to application of judicial estoppel, non-disclosure in bankruptcy proceedings differs from an allegedly inadequate disclosure, particularly in Chapter 11 and Chapter 13 cases as compared to a Chapter 7. Because Chapter 11 cases Chapter 13 cases are ongoing cases. Indeed, if you were to check the court docket in the bankruptcy court of this case, the underlying Chapter 11, today, tomorrow, whenever, what you will find is that case is still going on. There are quarterly reports filed. If there is ever a recovery in this case, we have to go back to the bankruptcy court and get it approved. So,
Well, don't your clients also have an obligation to disclose this potential claim, even if it's not filed in their preliminary schedule?
they did disclose.
Where in that schedule did they disclose the potential for this claim?
If you're looking at the statement of affairs, that's one issue, but this is a Chapter 11. And Chapter 11.
It is now.
What?
It is now.
It is now. And in the small business Chapter 11, which is a relatively new character, the disclosure requirement of Chapter 11 and the plan are combined. And the bankruptcy court here explicitly approved the disclosure statement. Now, let me point out, respondents could have objected. They could have demanded more information. They could have filed an objection to discharge. They could have filed an objection to dischargeability.
What's your authority that that's their obligation? That they would, as a creditor in a bankruptcy proceeding, that they would have to come forward and say, hey, we need to litigate this here?
They don't have to, but they can, and I'd certainly suggest they do that rather than embark on this kind of campaign. I do want to turn, I've only got about 2 minutes.
Right, I actually want to go back to my judicial estoppel question. Where did you argue in briefing that the later position alleged by opposing counsel is not clearly inconsistent with the earlier position in terms of their claim of failure to disclose?
Sorry, I don't think I understand your
It's the
question.
I'm asking you to apply the factors for judicial estoppel because of my concern that all
Sure.
we had in briefing was a conclusory
There
statement.
was disclosure. No, I just respectfully disagree.
I understand that. I want you to
There was
explain it.
disclosure to the bankruptcy court. There was an opportunity for them to litigate it, which they did not take. There was no damage. There is no damage to them. They can make the same demands that they could make in any Chapter 11. I do want to get to the Criminal Profiteering Act. It's important to understand in this case what is not before your honors. The only showing by the respondents in the trial court was that we have to establish mens rea on the part of the respondents. And
Well,
that
didn't
is,
they say you have to establish a prima facie showing of the elements of your claim?
well,
And they focused on mens rea.
they didn't just focus, they only addressed mens rea. That's the only issue. If you look at Clerk's Papers 427, if you look at 572 in the transcript of the hearing, the following issues were never raised on summary judgment and are not before the court. And I want to finish this answer if I can. Whether Williams' conduct constituted predicate criminal offenses. That's not before this court. Whether it was extortion, whether it was an unlawful practice of law, whether it was unlicensed practice, none of that is before this court.
Counsel, would you like to take another minute out of your rebuttal or come back on rebuttal?
I'll take another minute now. Secondly, whether an enterprise existed, not before this court. Whether Williams committed a pattern of criminal profiteering activity, not before this court. Thus, the only issue before the court is the issue of whether all participants in the enterprise must be proven to have had mens rea. That's the only summary judgment issue. Thank you.
Thank you, Counsel.
Good morning, Your Honors. May it please the Court. My name is Dan Rankin. I represent Danielle and Angelina Odievich. I've got Alex Ortiz with me as well, representing Nona Adams, but I'll be doing the speaking for the defendant respondents. We ask you to affirm the trial court's dismissal, the two summary judgment rulings, and I want to start with Your Honor's questions about judicial estoppel. It is not an open question of law, it is settled. We review a trial court's decision to apply the equitable doctrine of judicial estoppel for abuse of discretion. That's from Arkeson versus Ethan Allen of the State Supreme Court. I don't think we need to talk more about that, but I can take questions on that if you have any.
Can you address counsel's argument in briefing, and then you carried through with the additional authorities, that your clients are collaterally estopped from presenting argument on judicial estoppel because they could have and should have litigated any concerns in the bankruptcy proceedings? They could have, should have opposed or challenged the claims there.
Yeah, so the case law holds that a debtor who's also a plaintiff in a different suit, they have to disclose these things in their asset disclosures. I think you rightly saw that. And there is, I think you correctly pointed out, no precedent saying that if you are a defendant in a lawsuit who's also a creditor, you have to litigate that in the bankruptcy court. In this particular instance, my clients just wanted to be done with the whole situation. And so they didn't contest any discharge. They didn't contest the conversion from Chapter 7 to 11. And there's no obligation for them to do so. When they became defendants in this lawsuit, one of I hesitate to call it a defense because it's not an affirmative defense according to some case law. It's a judicial tool in equity to preserve the integrity of the court. And so, for example, you don't have to plead judicial estoppel in your answer. The court can apply it on its own. We did bring it up to the court, as we thought was appropriate, because there was a clearly inconsistent statement. And so the bankruptcy court took the asset disclosure, presumed to be true because it's signed under penalty of perjury, and the trustee and the creditors looked at that and said, okay, based on this, we're going to go forward in ABC ways. They did that on the assumption that the Sherbinens were honest and accurate and complete. And then when we got to the trial court and the plaintiffs there alleged $13-some million in damages in discovery, the trial court said, hold on, you told the bankruptcy court there is not a claim here, but you're telling us there is a claim.
And so can you address opposing counsel's argument that the plan of reorganization dated September of 21 is sufficient to kind of satisfy those concerns?
Absolutely. So the ARP case and the Hamilton case both address similar situations. There's nothing exactly on point for the bankruptcy reorganization plan, but in ARP, I believe it was a bankruptcy motion. It was disclosed, and in Hamilton, it was a letter to the trustee. Both of those courts, one a Washington court, one a Ninth Circuit court, said, no, it has to be in your asset disclosures. And that makes sense here because in the proceeding of a bankruptcy case, you file your disclosure, the creditors and trustee meet, and then based on that information, they put together the bankruptcy plan. So the first instance that this is mentioned is in, one of the last pages on this long document, and it says, not, by the way, we have a $13 million claim. It says, we reserve the right to ask for court's permission to hire an attorney to scrub defamation off of the internet. That's what it is. And so I think counsel correctly points something out, that there was a Chapter 7 to a Chapter 11 conversion here based on the schedule of assets that did not include this. And part of that conversion is the creditor's determination of which plan is better for us. Had there been a $13 million claim disclosed, the Sherbinens had $8 million in debt. That $13 million claim, if meritorious, which it is not, but that would have satisfied every debt on there. And there would be certainly a different plan forward, potentially not even converting to a Chapter 11. And so that kind of leads into the three elements of judicial estoppel. The earlier inconsistent statement, telling one court we don't have a claim, telling the state court we have a big claim. reliance by the court, and this touches on the full faith and credit piece, the state court did not fail to give full faith and credit to the bankruptcy court's bankruptcy plan. In fact, they said, here's a bankruptcy plan which is implemented and is going forward, and it includes this, inconsistency. And then the benefit and the harm piece. There is no requirement that my clients be harmed as a result of it. Two other things apply, though. One, there's a lot of case law that says judicial estoppel protects the integrity of the courts from these inconsistent statements, and also the benefit to the Sherbinets. There's case law that talks about you can't, hide your rights while you have all of your debts discharged. Then when they're gone, suddenly you've got this bundle of rights or assets that were outside the scope. And again, I want to point out, intent can be considered, but it does not have to be considered. This is not the only situation of this with the Sherbinets bankruptcy. There was the Bellevue Property Investors Group asset not disclosed and situated in such a way that it wouldn't come to fruition until after the bankruptcy plan was filed. Then suddenly they've got millions of dollars in assets outside the view of the bankruptcy court.
Counsel, does your judicial estoppel, or does the court's judicial estoppel determination, based on your argument, also capture any Criminal Profiteering Act claim? Wouldn't it apply equally? I realize procedurally that's not how this happened.
Right. Had all of the things been in the same summary judgment motion, then yes, the judicial estoppel would have applied to the criminal profiteering claim at that time.
Because the schedules and then later the reorganization plan had occurred prior to Judge Campagna's summary judgment dismissal of the Criminal Profiteering Act.
Yeah, I believe that's right, that it would have applied there as well. And if for some reason the Criminal Profiteering Act claim is reinstated after this appeal, I believe judicial estoppel would still bar that claim as to Vadim and Valentina. I will move on to the criminal profiteering claim. And so there are two rulings that the trial court made on this issue. One is that there is a mens rea requirement on criminal profiteering, and two, there's an absence of facts supporting that here. That second one is not at issue. There's no question about whether the evidence was weighed correctly or whether there's a genuine dispute of material fact. The only issue is whether the law requires that mens rea be established.
Can you respond to counsel's argument that the other elements required to establish a claim under the Criminal Profiteering Act are not properly before us?
That's right. We didn't move on those bases in the trial court.
Do you agree that we have case law that says we can affirm on any basis supported by the record?
Absolutely. Absolutely. And should this go back there, I do fully expect that we would bring a summary judgment motion on those other ones, but on the simple issue of the law, that was our decision to move at that time. And so the state RICO Act, Criminal Profiteering Act, basically says you're liable if you lead organized crime or you do organized crime. There's separate statutes for both, all within the act, and the claim here is essentially that my clients and Ms. Adams hired a guy who then went out and did organized crime. But that's really leading organized crime. That's what the claim is. And that requires two levels of mens rea. To the extent that there's an allegation that my clients did organize crime, either by intent or solicitation or as a co-conspirator, that also requires mens rea, which is absent here. And for that, there's ample Washington case law that says if you're a co-conspirator to establish liability, you have to have the same criminal mens rea. The last point I want to make is the Federal RICO Act and the State Criminal Profiteering Act are structurally different, and it was intended that way by the legislature. An earlier case went into the legislative history and said the state legislature was concerned about federal overreach and intended to make it narrower. Thank you, Your Honors.
Thank you.
Your Honors, in my very limited time remaining, a couple of things. First of all, Your Honor asked whether we could affirm on any basis. As a matter of due process, long history, there has to be an initial showing on summary judgment. There's been no initial showing on the merits of the Criminal Profiteering Act issue. Secondly, counsel argues, well, there's $13 million. There's no disadvantage, no prejudice to them. That's still there. That's still subject to bankruptcy court jurisdiction. So they can't meet the requirements of judicial estoppel. Finally, let me refer the court to the cases of Hazlitt versus Plank, P-L-A-N-C-K, 140, Washington Appeals 660, which go to the issue about the difference between Chapter 11 and Chapter 13, and counsel's representation about the judicial estoppel, and just two other citations. Baldwin versus Silver, 147 Washington Appeals 531, and Newell versus Pierce County, which was decided after our opening brief was issued. Two of your honors were on that case. So thank you very much. We ask that you reverse. Thank you.
Thank you, counsel.